LREI versus DeQuita Coleman.
Zoom.
That is for non-payment.
DeQuita Coleman, good morning. Would you like to ask your landlord for a standard agreement to either pay in full or vacate to avoid eviction?
Judge Rebecca Cotton for Ms. Coleman.
Ms.
Good
Cotton is on
morning.
the line. Ms. Cotton, good morning.
Good morning, Judge. We are requesting a hearing in this case. Ms. Coleman is on the Zoom. Judge, we have multiple defenses and reserve the right to use any defense, but we will be making arguments concerning notice waiver and substantive defenses.
Your Honor, I'm going to need a little more specificity than that, or I'm going to have to reserve my right for CR 11 sanctions against Ms. Cotton, as she has the notice and is very much aware that it's valid. Because Ms. Cotton used subterfuge to get a copy of the notice, but knowing that we won't provide things to her because of her past behavior, she had Dinsmore and Shull's paralegal reach out to us to get it on behalf of her voluntary eviction program.
Judge, Mr. Benz provided those documents, and I had nothing to do with that.
I stand by my statement, Your Honor.
Back to the matter at hand, there's a defense on the issue of
She's been very vague. I have no way to prepare for a hearing when she's just going waiver, substantive defenses, and notice. She's not alleged anything that tells me what I'm preparing for.
Okay, give me 1 minute because I try to write these things down. So, Ms. Cotton, I have written down the word waiver.
Yep.
What else did you state, or is there anything else you can provide the court or Mr. Ben so he can prepare for the hearing on 3/9 at 1 o'clock? That is my next hearing date. We are already up to how many ladies? 6 or 7. We have 9 on 2/23. In case you all are wondering why I'm going to 3/9.
I've dismissed one of those for you earlier today, I think, Your Honor.
Okay, that's still so now it's 8.
I only had one, so I can only do my part.
Right, I appreciate it, but just letting y'all know we are on 3/9. I scheduled 2 huge ones this morning where a detective is going to be testifying, so that will be those will be long hearings. So
I'm available, Judge, on the 9th.
Okay, on 3/9. And would you like to put anything else on the record, or are you going to submit something to in writing to Mr. Benz with regard to the defenses?
I am drafting, Judge.
All right,
We would like that on the record today. We'd like it on the record today, Your Honor, because we don't believe she's articulated a good faith basis for the hearing without pitting something into the record now.
We have no obligation, Judge, to prove our right to a hearing. It's guaranteed by statute.
Actually, it's not, Your Honor. The hearing today is guaranteed by statute. Having a separate call is not.
That's the court's provision that they determined that they're going to set their dockets and that they're going to do trials on certain dates. Legal aid has nothing to do with that.
And Ms. Cotton is aware she has to have a good faith basis and to be able to articulate that. She is refusing to do so because, as I stand by my earlier comment, she has no good faith basis. This is then surely to cause delay and increase the cost of litigation.
Okay, Mr. Benz, give me a minute. Mr. Benz, this is getting kind of, I feel like it's very argumentative, and I just want to make sure that we are fair to both sides. I have never had Ms. Cotton in my time here, which has been about a year, bring forth defenses on something that were not in good faith and were not valid. So I
have it on a regular basis.
I don't know where this is coming from, but Ms. Cotton, just to kind of meet in the middle, is there anything else you can tell me with regard to waiver, such did they accept a payment? Can you share anything else for the record so that we can move on?
Judge, I don't feel like laying out my whole case right this moment.
No, I don't need you to lay out the whole case. Can you give us a hint? You said waiver. Usually you all tell me it's the notice is not good. You tell me they accepted a payment. Is there anything you can share with the court to meet us in the middle here?
Sure, Judge. Improper notice.
Objection.
One of our
knows that's not true because she has
the notice. Judge.
Sir, you asked for her to lay it out. You're going to be making your motions and no objections and all of that at the hearing. You asked her for an answer. Right. She's trying to give it.
What's improper about the notice would be
Sir, this is not the time for the hearing, Mr. Benz. Right. This is not the time for the hearing. Do you want to assert anything other than improper notice, ma'am? Ms. Cotton?
Judge, only what I've already stated before: improper notice, waiver, and we have substantive defenses.
All right.
Your Honor, for the record, when this is concluded, we will be presenting our motion for CR 11 sanctions against Ms. Cotton.
Noted, and we're going to move on. Hearing date scheduled for 3/9.
Your Honor, before we go any further, I'm also going to request that she have everything filed that she plans on filing the Wednesday before this hearing, so I have time to respond.
Okay, so do we want to write on the record, I think earlier when they did 2:25 and then responding by 3,
I
5,
would get to the end of that business that Friday before the hearing, so it would
will you
be
be able to do
3/6.
that, Ms. Cotton?
Judge, the court has repeatedly informed Mr. Benz that there's no obligation to file any motion to dismiss.
That is incorrect, Your Honor, and that is a flat lie by Ms. Cotton. The court has routinely told Ms. Cotton and legal aid that the court requests that they file these arguments and documents in advance and give the plaintiff time to defense. Again, this goes further to show Ms. Cotton's argument is nothing more than a lay tactic and to increase litigation, and she has no good faith basis, or she would bother to put it in writing and file it with the court like requested.
Ms. Cotton, the hearings that I scheduled earlier at the 9 o'clock hour, the attorneys were willing to provide. I'm going to ask that you provide the defenses and the motion to dismiss prior to the hearing so that Mr. Benz can prepare number 1 and number 2 respond.
Thank
Can
you,
we have a
Judge.
date on that, Your Honor, so we can have it in advance in time to respond?
I was in the middle of trying to ask it, Mr. Benz.
Yes, ma'am.
Judge, we will do whatever the court requires, but I maintain that there's no obligation for legal aid to file a motion to dismiss. It is Mr. Benz's burden to prove his case.
And I maintain that it's my position that Ms. Cotton has to have a good faith basis, which she does not, and is subject to herself to sanctions, which she opened this can of worms on herself by filing her nonsense motion a few weeks ago for that.
How about, what did we say? 1 week from today is 2/26, and then would they give Mr. Benz, when would you be able to respond to that?
I would give Rebecca, Your Honor, I would be willing to give her until, since you're doing this on the 9th, I'd be willing to give her, she can have everything she wants done by the 3rd. I'll have my response filed by the close of business on the 6th.
Miss, is that acceptable to both counsel?
Judge, if the court is requiring me
I
to
am. I would
file,
like.
then I am willing to do so.
Okay, very good. I am asking that you file your defenses, please, on 3/3, and then Mr. Benz, you said you'll respond by when?
I'll have everything filed by the close of business that Friday, 3/6.
All right, very good. Thank you. Moving on. Summerfield versus Lanisha Bell.
That is for non-payment.
Looking for Bell. Proof of service is in the file. You done with court yet? Good morning. My name is Judge. Is this a live person I'm speaking with?
Yes.
Good morning. My name is Judge. I'm sorry. Every time I try to say something, may I speak?
I think I took a pause just now. You can speak, but I don't think you heard me in the beginning. Probably is a delay going on.
Oh, okay. Okay, because first I thought it was a machine. I'm trying to get this in really quickly. I'm Judge Lisa L. Langford. I'm live on the record in eviction court. I'm looking for a Lanisha Bell at 48 here in Louisville. I have the landlord and their attorney on the line. Today is the day for her hearing. Is this Lanisha Bell?
No, it's not. This is my Linda.
Okay.
One moment.
I don't know. Oh, I'm listening to classical music now. I do.
Hopefully it's good music.
Yeah, I was gonna say I love classical. I used to be in the orchestra, so I love it. I don't know how long we're gonna listen to it though.
Okay, Judge, I'm back for you. Now, I'm their virtual receptionist here. I'm looking through my directory. I don't see a Lanisha Bell and the address that you mentioned.
Oh, so this is a work number she
here.
gave? This is a work number? When you say you're a virtual assistant, are you... I don't know what a virtual assistant means.
Which means I don't work directly in the office. Now, if you're trying to reach J. Christopher Robinson, the two addresses listed is not
No, ma'am. No, let me stop you there because I've already gone on this call too. I give people 30 seconds. I'm trying to save her from losing her home. So if you do not know who Lanisha Bell is, we are going to move on with her eviction. This was just a courtesy call to try to help her save her home. Thank you for answering. Have a great day. That was really strange, you all. That was odd.
Yep. Okay. Go. Will you hand me my scream box?
Now go.
Louisville Metro Housing versus Glenn Sidnor. Miss Avery, good morning. I see her name. Gretchen Avery, are you there?
I'm here. I'm having technical difficulties this morning, Your Honor. I'm here.
I know. We don't get to see you.
Metro Housing Authority.
We can hear you. That's it.
And there's an out.
You said there's a what?
There's some kind of internet outage in my area, so I'm trying to.
Well, we can absolutely hear you. We're going forward on Glenn Sidnor.
We are.
Okay, very good. Let me see if I've got service and a phone number. Service is in the file, and here we go.
The subscriber you have.
No one is answering at 9:15 a.m. Who do we have?
Your Honor, I should have Cherie Harris on the line, as well as there should be a couple LMPD police officers I subpoenaed if necessary.
Oh, okay. Miss Cherie?
Yes, ma'am.
Oh, there you are. Good morning. We can see you.
Okay. Can you hear me?
Cherie Harris, may I swear you in for any testimony? And they said there might be some police officers' testimony needed as well.
Yeah.
Maybe, yes.
Okay, should I go ahead and swear them just in case?
Please.
All right, officers, can somebody tell me which officers are needing to be sworn? What their last name would be sufficient for me.
Forshee and Gibbons.
All right, officers, if you all are there, I'm going to ask you to raise your right hands and let me know if it's raised, and we'll begin with the swearing. Do you swear or affirm that the testimony that you're about to give the court this morning is the truth, the whole truth, and nothing but the truth? Ms. Harris and officers, I need to hear 3 people say yes.
Yes.
There are no officers on Zoom, Judge.
Oh, I thought she said they were in the room with Ms. Harris.
So they should. No. They said they should be.
Oh, I'm sorry. I misunderstood. Well, we're going to go forward with Miss Harris for now then. Miss Harris, you're good. I've already sworn you, okay?
Okay.
All right, very good. And then if the officers come in, would you let me know, Miss Oliver? I misunderstood what was going on. All right, very good. So this is regarding a Glenn Sidnor. Miss Avery, please begin.
All right. Miss Harris, please state your full
wait a
name
minute. Here's an officer in the room. Sorry. Hold on. Officer, what is your name? Would you come up to the stand, please? A lot of confusion going on right now. Do you swear or affirm that the testimony that you might be getting ready to give is the truth, the whole truth, and nothing but the truth?
Yes, Judge.
And I'm sorry, may I write your name? What is your name for the record?
Detective Jeffrey Gibbons.
Detective Gibbons?
Yes, ma'am.
Jeffrey? All right, you want to have a seat next to Miss Kayla, and we'll determine whether we need your testimony in a moment.
Perfect time.
All right, thank you, Detective. We appreciate you being here. Okay, we will start with Miss Harris. Go ahead, Miss Harris.
Okay. Miss Harris, please state your full name for the record.
Cherie Harris.
And Miss Harris, are you employed by Louisville Metro Housing Authority?
Yes.
And are you employed as a property manager for the property located at 17?
Yes.
And is the tenant that is on the lease for that property Glenn Sidnor?
Yes.
All right. And was notice sent to Mr. Sidnor on or about December 5th, 2025?
Yes.
And was that notice sent pursuant to an allegation of, illegal activities occurring within the unit as reported by Louisville Metro Police Department?
Yes.
And once you received the report from Louisville Metro, did you send this notice on December 5th via certified mail?
Yes.
And did you also have it hand delivered?
Yes.
Once this notice was delivered to Mr. Sidnor, did you have any conversations with him afterwards?
No.
Have you all checked the unit to see if he's still residing in that unit?
Yes.
Is he still there?
Yes.
Okay. And the activities that were listed within the lease termination notice were drug related as well as, other lease violations. Is that correct?
Yes.
And was Mr. Sidnor's eviction in concert with at least 3 other evictions that were filed by the Housing Authority based on investigations by Louisville Metro Police Department?
Yes.
And based on that, are you requesting this court to enter a judgment on behalf of the Housing Authority?
Yes.
Yeah, that's all the questions I have for Ms. Harris.
Okay, Ms. Avery, I know when there's lease violations, they're given a different amount of time and then they're given a opportunity to cure. So I don't know if those questions were asked, if you could cover those in your colloquy, please.
The notice that was sent on December 5th, was it a 14-day notice for Mr. Sidnor?
Yes, it was.
And Your Honor, actually, I probably should ask the police officer the remaining of the questions regarding that notice. So that's all the questions I have for Ms. Harris.
All right. Somebody's walking in the door. I'm just trying to make sure it's not Mr. Sidnor. Just ask him if he's Mr. Sidnor, please. He is not. Okay. All right. We are going to turn the testimony now over an officer, a detective. If you feel comfortable sitting there, it's fine with me. If you want to answer, Attorney Gretchen, this is the first time I've had a detective in, so this is going to be first time for both of us.
My first time
in eviction court. So here we go. So just Miss Gretchen Avery, the attorney for Louisville Metro Housing, is on the Zoom, and she will be asking you the questions. And then of course I could ask follow-up if it's something I need.
Yes,
so
ma'am.
Please answer her questions. You've already been sworn. Okay,
Yes,
go ahead.
Of course.
Detective Gibbons,
Yes, ma'am.
please state your name for the record and who you're employed by.
Yes, ma'am. I'm Detective Jeffrey Gibbons. I'm employed by the Louisville Metro Police Department in the 2nd Division.
And as your involvement with 2nd Division, does that include the Park Hill Housing Complex?
Yes, ma'am, it does.
Why were you at the Park Hill Housing Complex on or about November 17th, 2025?
So I had been conducting a narcotics trafficking investigation into several different subjects that either resided in or spent time in Park Hill consistently. And the operation on November 17th specifically was the execution of 4 individual residential search warrants at 4 separate apartments in the Park Hill complex.
Okay. How long had you been a part of this surveillance that was occurring at Park Hill?
I've been conducting physical and electronic surveillance for approximately 3 to 4 months prior to the search warrants themselves.
Okay. And in particular to Mr. Glenn Sidnor, had you been investigating or surveying him that entire time?
So I wasn't aware of Mr. Sidnor or his location until roughly October 13th, approximately, give or take a day or two. So give me some grace on that. But I actually had been investigating an individual subject, and Mr. Sidnor wasn't a part of the investigation until mid-October. I actually received an anonymous voicemail, believe it or not. Someone called my sergeant, called his cell phone from a blocked number and left a voicemail regarding the primary target I had been investigating previously. And she, that subject, the female on the phone, and still I'm not sure who it was, but she had stated that the subject I was investigating had a new apartment that he was selling out of. And she said that it was the building, I believe it's building 55, 1731 Patton Court, apartment M. She didn't name Mr. Sidnor. I found out Mr. Sidnor's identity, and he became involved once I got the information from LMHA on who was leasing the actual apartment itself.
Okay. And after you observed Mr. Sidnor, and you then requested a search warrant for his unit?
Yes and no. Shortly after I became aware of the apartment, I began conducting surveillance on his specific unit. And I was able to build the probable cause I needed for a search warrant shortly after that, just before November 17th.
And when you executed that search warrant, what did you find within that unit?
So Mr. Sidnor was inside along with 2 other people, if I remember correctly, a DeMonte Parrish and a Jerica Major, if I remember memory serves. The contents of the apartment itself, there was individually packaged marijuana, so in little Mylar bags. That's pretty common. And then there was a small amount of currency and some other paraphernalia indicative of either drug use or drug trafficking, one or the other.
Oh, okay. And was anyone arrested from Mr. Sidnor's unit?
So Mr. Sidnor, Miss Major, and Mr. Parrish were all 3 cited and released in relation to that. So, excuse me. I believe, if I remember correctly, they were all cited and released for trafficking marijuana and between 8 ounces and 5 pounds, if memory serves.
Mm-hmm. Okay. And is it your normal routine to have, I guess, interaction with Park Hill as part of your beat or part of Division 2?
Yes, ma'am. Yeah. So Park Hill is one of the areas that I conduct investigations in, among many others. But it is an area that I spend time in fairly frequently within the 2nd Division.
And is that an area that is, I guess, having a rather high level of issue with drug trafficking and other criminal related activities?
Historically, yes. We've actually had a pretty significant reduction in crime in general, specifically violent crime in Park Hill, due in part to a lot of our just increased presence there from patrol officers and an increased effort to try to stem some of that violence. With the weather warming up, we're hoping that continues, but we're cautiously optimistic.
And as part of I guess, cleaning up the Park Hill situation, are evictions playing a role in getting these offenders, I guess, removed from the units that are within that complex?
Yes, ma'am, it is. Unfortunately, LMDC is full. I'm sure overcrowding is an issue. We're all aware of that. But, whenever you're dealing with individuals who aren't necessarily being booked for violent crimes, they do get released a lot of times, whether that is from, a bond that they post or maybe they get ROR'd or whatever the case may be. And so, it helps us to have some teeth on the back end when we partner with LMHA to keep those people from being able to just go right back to the unit they were in and continue with the activity that they were doing in the first place. Okay.
And have you continued to survey Mr. Sidnor's unit, or have you stopped since you've executed that search warrant?
So I do have Park Hill, the complex in general, has many cameras. There is a camera that can face Mr. Sidnor's apartment. It doesn't face it all the time. I do turn it from time to time just to see if there's any continuing activity. I'm not going to say there hasn't been at all because I'm not able to watch it 24/7. But in the times that I've observed the apartment, there isn't any drug activity that I've seen or noticed, especially on the scale that there was prior to my search warrant being executed.
All right. And that's all the questions I have for the officer, Your Honor.
So let me clarify, okay, hold on. So we got to deal with some dates, right? So the defendant was given written notice to vacate on December 5 of 2025. And so we would have to count, said you gave him 14 days to vacate or to cure.
Well, no, they didn't give him right to cure, Your Honor. They gave him a straight termination letter based on the, I guess, the concerns that are within the complex of that the escalated drug selling is an ongoing concern for the unit as well as the safety of other tenants.
And so are you going to, I guess in your closing argument, you're going to let me know why you do not believe the right to cure applies to this particular property?
I will.
Okay. All right. Now, while we were talking, my deputy noted that Mr. Sidnor has come onto the Zoom. Mr. Sidnor, if you will please press *6, Glenn Sidnor. And so he did, I believe, he'll verify, or I'll have him verify how much of the testimony that he caught. Good morning, sir. Would you please state your name for the record?
Glenn Sidnor.
All right, Mr. Sidnor. So at what point did you come in? Was the detective testifying when you came into the call?
Yes, Judge, that's when he came on to the call.
Okay, thank you, Ms. Oliver. Yeah. All right, so you were case number 1, so we started pretty much right on time, sir. Let me ask Miss Avery, are you all willing to offer him any kind of, I'm sure there's not going to be a standard agreement to pay and stay. Are you willing to offer him a standard agreement? I guess, well, first of all, with him being late, he didn't even hear his rights. So, sir, let me go ahead and tell you the opening. I'm going to read the opening for eviction court. There were a lot of people late this morning. Court starts at 9, folks. So I'm going to take the moment. Who said, oh, my God?
That was me, ma'am.
Okay, could you listen while I read the opening, please?
Yes, ma'am, sorry.
All right, thank you. No comments, no commentary needed. All right, so this is eviction court. Everybody knows that. What we're here today is for your hearing for eviction, for whether it be for non-payment of rent or some other violation, which in Mr. Sidnor's case. But either way, there is something called a standard agreement, which is something here in Jefferson County in cooperation with some landlords that instead of having your hearing, the court could pass your case 1 week to either give you the additional time to pay in full all that's due and owing by certified funds to your landlord. Today is February 19th. So they're expecting whatever you owe, including up to February 19th. Or you can completely vacate the premises in turn. Could somebody mute Mr. Sidnor, please? Or you can completely vacate the premises and turn in the keys before we call the case next week. Now, before you consider accepting the standard agreement, there are 3 things that you will be waiving if you accept the standard agreement. You will be waiving your right to appeal, your right to a jury trial, and your right to assert any defenses you may have in your case. Now, knowing that, if you decide to go ahead and accept the standard agreement to either pay in full or vacate, we will review your case next Thursday at 2/26 at 11 o'clock. At that time, I will ask you if you followed your standard agreement. If you did, you will get a dismissal with no eviction. However, next Thursday at 11, if you have not followed your standard agreement, meaning you did not pay, nor did you vacate, then the landlord will be entitled to what's called an eviction judgment with immediate possession, meaning they would have authority to go and ask for an eviction warrant and to contact the sheriff's office. Now that you're fully apprised, Mr. Sidnor, it has been, and I will put on the record since you missed most of it. The other violation in your case, it says on or about November 17, 2025, LMPD executed a search warrant on your unit and found approximately 8 ounces to 5 pounds of marijuana. Other suspects were charged with distribution and removing drugs from your unit in an attempt to conceal narcotics and other evidence. Drug activity, possession, distribution is a violation of the lease. Again, you were given written notice to vacate on December 5 of 2025. And the allegation at the time this was served was that you had not vacated. And I believe the testimony that you missed from Ms. Cherie Harris is that you still have not vacated. Now, Mr. Sidnor, you may unmute. And you may tell me that you understand what I just told you.
Yeah, but like I said, ma'am, I wasn't here. I'm in that hospital. I have stomach cancer. I didn't know the guy
I'm not understanding what you're saying. You weren't here or you're not there. You're no longer living there?
No, I stayed there, but I was in the hospital. I said, when I came home, I was in the front room, it was in the back. Whatever it means was in the backpack or whatever. I didn't know
Wait a minute. Don't talk about, no. Don't talk about the facts of the case, sir. This is not criminal court. This is eviction court. And we are here to determine whether you should be evicted today. That's all I care about. So I don't know whether you were there or not, but this is your property. Is that correct? Do you reside at 17?
Yes.
Mr. Sidnor, that's a yes or no question.
I say yes, ma'am.
All right, Miss Avery, what are you willing to offer him with regard to a resolution on this today?
We're offering him the right to vacate, Your Honor.
All right, sir. I read to you what the standard agreement is. Are you willing to take the 7-day standard agreement, which again would give you until 2/26 at 11 a.m. to completely vacate the premises and turn in your keys?
I was going to try to pay the thing.
Sir, I'm not understanding a word you're saying.
I thought I was going to try to, like I said, to pay for it.
I can't hear what, because anybody know what they're saying?
I think he said he wants to try to pay, and this is not a non-payment.
That's not an option. They want you out of there because of your criminal behavior, sir.
I didn't do
You're
it.
alleged. I should say alleged. Detective, real quick.
Yes, ma'am.
Follow-up question. Are these cases still ongoing or have they been resolved?
No, ma'am.
So
They're
then
still
it's
ongoing.
alleged criminal. Sir, I'm not talking to you. I'm talking to the detective. Detective.
Sorry.
Miss Oliver, would you mute him again, please? He can't seem to control himself.
Yes, ma'am.
All right. So, and this is very common in this court. Detective, again, I will ask you the question. You're still under swearing. Are these cases still ongoing?
Yes, ma'am. They're still in circuit court.
They're still in circuit court, so they have not been resolved. And is he represented by an attorney up there? Do you know? You may not know.
I'm not 100%
But if he is, he
positive.
probably should not be making statements because anything that he says on this record can be then pulled and used in circuit court.
Yes, ma'am.
All right, so I will correct my language to state that the allegations, sir, of this behavior are still ongoing. I would highly advise you not speak as to the allegations. LMHA wants you out of there because of your behavior. Miss Avery, we have talked about the fact that he wants to stay. You're only willing to let him vacate. I was trying to determine whether there was any evidence after the notice that he was given time after the notice. Was there any additional behavior that was noted that can be put on the record? And that may be you, detective. So they're supposed to be given 14 days. Miss Avery is going to tell me why she believes he does not have 14 days to cure. The law states he does. So do you have any evidence of any additional behavior from this individual after that initial hit on the 17th?
I have not interacted with Mr. Sidnor since that day on the 17th, so I can't speak to what his activity has been since
Okay,
then.
and I know you probably don't want to disclose different investigations that are going on now. I can understand that. All right, Miss Avery, the ball is in your court at this point.
Your Honor, the issue is this, as the detective testified to, this is an ongoing issue that wasn't a one-time thing that can be cured. This is something that he caught wind of this particular tenant in October and only stopped once he executed the arrest of the search warrant and gave the citation for Mr. Sidnor. This is the issue with all four of the petitions that were filed today. Some include gun possession, some include larger amounts of drugs, some include other things. And there's some things you just can't cure. And if you've brought a criminal element to a complex that has families within it, it is the housing authority's belief, and as well as HUD's belief, that you have to cut it off quick to avoid there being anything that's even more disastrous, such as loss of life or anything that usually is surrounded by the drug trade that is occurring in public housing. Although some people think that you can cure it, I think once the crime has occurred and it's an ongoing issue that is a part of a police investigation, there's no cure that can be had except for removing that element from the complex to ensure that the safety of other tenants is considered. If you look through most of these cases, this is not a one-time drug deal or a visitor's drug deal. It involves the actual tenant that has created an environment that is not safe for the employees or the people who actually reside in that complex.
And you mentioned HUD. Is there something in the language that overrides the law here in Jefferson County, that overrides your RALTA, which provides him a right to cure, meaning that if he stops the behavior, that he would be given the opportunity to continue to. I understand what you're saying. Let me start off by saying I absolutely understand what you're saying, and that this is not the element that you want in this area, and that it's probably a very small percentage of the folks that live in that area, and they should be able to live. I don't want to make an argument for you, but I'm just kind of recapitulate, okay? But the bottom line is we do have to follow the law.
And the law says that it has to be a curable offense. The problem is, once you've done the deed, some things can't be undone. I mean, the damage is done, the element is there, and you just can't. This goes back to my argument that you can't hit someone and then cure it. You've already done the damage. You can't undo the impact of your damage, and every action has a consequence. And the fact that there's a choice to drug deal in an area that is for families and children, the impact is done. You can't undo that. There's no go back and fix that. There's no cure to that because the damage is already done. This is not an incident where he didn't cut his grass and didn't cut his grass for a long time. We're like, cut the grass, cuts the grass, and he's back in compliance. This is an element of crime that has impacted every tenant that lives there, and you can't undo that impact. It's done. So I'm not sure what there is to cure once you've already created, excuse me, an environment that is significantly impacted by the behaviors that Mr. Sidnor and his guests have engaged in.
And Ms. Avery, with all due respect, we have had this argument in this court several times. Again, I understand the side he wants to stay, and I think at this point, and if we have 3 more cases like this, I think they all need to go to a hearing docket. I think they all need to be given the opportunity to get an attorney to argue both sides of this. Mr. Sidnor, I'm going to ask you to unmute, and you are to only answer the questions that I ask you, because I need to hear the arguments again. I need to possibly have these arguments briefed. And again, we have basically already spent 40 minutes. We're now at 9:40, and you're telling me there are 3 more cases just like this on this docket.
There are 2 more. Yes, one's going to be dismissed with the person vacated.
Okay, so Mr. Sidnor, did you seek out an attorney to represent you on this case, sir?
Yeah, I talked to him today, so I am going to get my lawyer.
Well, where are they?
Yeah, cause I don't know. I left a
Where's
message
your
in the
attorney?
public. He's talking over me. It was in
I'm
the public
talking over
defender's
you
office.
because I want to know where is your attorney, sir? We've done one case in 40 minutes.
Okay, I guess I gotta get the lawyer then.
When did you get notice of this, sir?
About a week ago. On my door.
So you're just now
Hold
finding out that even though they gave you written notice in December, you're just finding out that you need an attorney today.
Yeah, I didn't know if I needed an attorney or not, because like I said, it wasn't on me. I don't know what I was getting charged with. I got home and then that shit happened.
Sir, do not talk about the facts of your criminal case.
Okay, ma'am.
Unless you want it used against you in circuit court.
Okay,
I'm going to set this for a hearing. Please stop talking. I'm going to set this for a hearing. Would everybody please check their calendars for 3/9 at 1 p.m. Sir, you need to reach out. If you can afford an attorney, you need to reach out to an attorney. If you cannot afford an attorney, you can certainly try reaching out to legal aid to see if they will be able to assist you on this matter. Again, 3/9 at 1 o'clock is my next hearing date that does not already have 9 hearings on it. Detective, did you shake your head?
9, just at 9 hearings, sorry.
Okay.
March 9th is available for me.
3/19. So the hearing date that I have that already has 9 hearings is 2/23. So that's why we have to go to 3/9 at 1 o'clock. Miss Avery knows how these schedules work.
I have it.
And so that is the next date I have available to spend more time on cases like this that need to be heard on both sides, and that the party needs to be represented since they are facing loss of their home. And they may need to lose their home, but we determined that from a hearing. So what did you say about 3/9, Miss Avery?
That works for me.
Okay. Mr. Sidnor, please write down the date of 3/9. That's March 9 at 1 p.m. hour. You need to be on time. You need to be either in courtroom 308 or to call back in the way you have. You need to have an attorney to represent you on this eviction matter. This is intertangled or intermingled, but this is a civil matter. This does not deal with your criminal court. Do you understand that? This is eviction court. I need a yes or a no.
Yes, ma'am.
All right, very good. You are excused unless you have further questions.
Thank you. But in God's hands, baby. Thank you.
What'd you say? I don't know what he said. This is here. Louisville Metro Housing versus Ricky Demas. All right, sir. Did you get an attorney for today? All right, come on up to the stand. All right, and he's on for the same exact matters. May we just say that, take your hands out of your pockets, please. So, sir, you are here for the same exact issue, but I will read it. You're on for other violation of lease on or about November 17. LMPD executed a search warrant on your unit and found approximately 3 pounds of marijuana, 200 grams of suspected meth, and a Glock 35 in your unit. The search was part of months-long DEA/LMPD surveillance. Drug trafficking, distribution, possession is a violation of the lease. It states here that you were given written notice on December 5 of 2025 and that you still have not vacated. Is that accurate?
Yes, ma'am.
Are you willing to vacate the property, or do we need to set you for a hearing?
Vacate.
He says he'll vacate. You said you all are offering him a standard agreement to vacate, Miss Avery?
Yes.
All right, so sir, I will read it to you again so that we make sure you 100% know. A standard agreement to vacate, sir, would give you 7 days from today. Deputy's going to write down the date. It is 2/26 at 11 will be your next hearing. On that date, I need to know that you have removed people, property, pets, everything. In other words, you have turned in your keys if there are keys to your landlord. And upon you coming back into court next week at 11, if you have done so, we will be able to dismiss this case with no eviction. Is that what you're prepared to do? All right, we're writing down standard agreement to vacate only. We are writing down that date of 2/26. Deputy has given you a yellow reminder card as well as the Zoom information so that you can Zoom in if you choose to do so rather than coming to the room. But we do need you here either way, okay? Thank you very much. You're excused. All right, the next case is, you said Ada Cole is the next one, and she is represented. Louisville Metro Housing Authority versus Ada Cole.
Yes, Judge. Andrew Chandler for the defendant.
All right, very good.
As
And
Ms.
this
Avery,
is a similar matter? Okay,
Yes.
can I read it real quick into the record?
Of course.
Good morning, ma'am. Would you state your name for the record? All right, good morning, Ms. Cole, and she's represented by Mr. Chandler, and she is here for other violation of lease that reads as follows. On or about November 17, 2025, LMPD executed a search warrant in your unit and recovered stolen guns, large quantities of marijuana, some laced with meth, pills, crack cocaine, paraphernalia used in distribution on, and a large amount of cash in a pillowcase. It is believed Tenant's son was trafficking drugs from her unit. Plaintiff gave defendants written notice to vacate on December 5, 2025, and to date, defendant has not vacated, well, at least as of then. And so we have an entry of appearance by Mr. Chandler. Mr. Chandler, please proceed.
Yes, Judge. We've entered an appearance and we've requested a jury concerning the facts of the case. I do think that we need to go ahead and get put on for March 9th. We're going to have a dispositive motion. I had filed our entry of appearance and our jury demand last week and communicated with Ms. Avery what our defenses would be.
Okay, very good. And that is in my file as well.
Yes. The first is, as the court identified, there's an issue of the right to cure and of the interpretation of housing authority of Covington v. Turner, which deals with similar issues in this case. I think it's particularly applicable to Ms. Cole because in that case, it was a family member who had engaged in the alleged illegal conduct. And it was the tenant who is being, put out for that. My client will assert factually that her son, who's the one who's been charged with these alleged crimes, that's Demetrius Cole. There is a circuit case or a criminal circuit case over there for him, but she has not been charged. And it's her position that he doesn't reside there anymore. She should have been given the right to cure. And by the plain terms of the notice, she wasn't. So we're going to be arguing for dismissal on that point. And on a second point, we're going to be arguing waiver. They accepted her payments for December and January. They did eventually return them in February. My client purports that they returned them to her February 12th, but they held those payments for what we would submit as a significant enough time that they could be deemed accepted. But I mean, they did return them. So we're going to need to make some arguments about that in a brief. And that'll be on a motion to dismiss for March 9th. And then concerning the facts and the alleged degree to which my client was involved in any of this, that's going to be something that'll have to be preserved for trial.
Very good. So jury trial demand is reserved. I've got motion to dismiss 1, right to cure, 2, the waiver based on a payment, was it from Section 8 or was it from her directly?
She gave them her portion. I could put on the record. I've got copies of her.
I don't think we need to be that specific, but it was
$268.
payment by the defendant herself, not Section 8.
Yeah, she made payment for December, $268. She made payment for January, $268. In February, she goes to make payment. They say, we can't accept your money anymore. And they gave her these old money orders back that we would submit that they accepted. So that's going to be the argument.
They had been held for.
And Your Honor, obviously my client has a different version of what occurred.
Oh, right, absolutely. I was gonna come to you next, Miss Avery. I absolutely, anything you want to put on the record to preserve, ma'am, but we obviously are gonna go into more detail at the hearing date. You go ahead, Miss Avery. Were you finished, Mr. Chandler?
That's it. That's our
okay. Go ahead, Miss Avery.
No, Your Honor, I'm just saying that obviously that's not our recitation of the facts, and I'm willing to do that on March 9th if you prefer, since we have a full docket we have to get through, or I can tell you now.
Ma'am, I would prefer that, knowing that you're always going to have your side of the story. We always have two sides of the story that we need to listen to. And I just didn't know, you did have a chance to at least briefly review what Mr. Chandler had provided to you, right?
He provided a jury demand and an entry of appearance, I believe.
Oh, okay. So
and he also sent me a copy of the money orders, I believe.
Yes.
So there will be an official motion to dismiss it.
Yeah, I'll brief it. Yes, we're going to file a motion to dismiss with exhibits, but I had sent Ms. Avery an email saying, here's our entry of appearance and here's these 2 arguments and here's the evidence I'm going to submit about them. So,
all right. So you were this, in other words, this was not a shock to you. I just want to put that on the record that you had some knowledge. And that we absolutely need to have a hearing on this. And is the officer going to be here as well?
That's my hope.
Does he need to be here for both hearings?
It's the same facts, so I would say yes.
Okay, so officer, you can be prepared to be here for both of these hearings.
I'm going to file our motion to dismiss with the court and obviously a copy to Ms. Avery, outlining our arguments more formally February 25th, and then I can expect a response by the end of the first week of March, sometime before the hearing.
All right, thank you. We're going to press on. Louisville Metro Housing versus Yelena Gibson.
Present.
Present in the room, coming forward.
Your Honor, Grace Chambers.
Ms. Chambers is on this one. Good morning, Ms. Chambers. Attorney Chambers for the defendant.
Yes, Judge, and Ms. Gibson is present and approaching.
All right, very good. Ma'am, would you state your name for the record?
Yelena Gibson.
Good morning, Ms. Gibson. All right, Ms. Chambers, let's hear from you. I imagine you have some defenses you want to assert.
I do, Your Honor. So Ms. Gibson was in eviction court, and that her case wrapped up. It was another non-payment. Case wrapped up in July of 2025.
Okay.
She pays her balance in full. The next month, she goes to pay her rent portion, and she says that the housing authority will not accept it because there's a $205 eviction filing fee. First of all, even if it was in the lease, I believe it should have been charged while the pending eviction was happening, so we would know about it and I would have time to address it. Secondly, and I don't believe that should be the sole grounds for forcible detainer here, which it is. She had her rent portion for August, the very next month, and she's back here again merely over that. And furthermore, it's not in, I can't find it in the lease. And I've seen this before, and I would, ask that we make sure we're not doing that, especially to public housing agency tenants. Especially put, for the fact that it's not in the lease. And now she's spent this whole time gathering up another arrearage. And she's back here. So they filed in December, they refused payment in August, filed in December, and now we're here in February. So
of course, again, this is regarding, not to cut you off because I know you're on the road, but this is regarding her portion. Is this a situation where she's got somebody else helping out? Okay.
Yeah, she has a rent portion. She went to pay for August after finishing this case.
Right.
And was refused.
And was specifically told the reason why is because she had a $205 eviction filing fee.
That's what
$205. Okay.
Yeah, I'm sorry, Judge. I didn't mean to.
No, I'm just, this is the first time I've heard this. I'm just a little surprised. Go ahead.
Yes, that is what she would testify to. She had her rent portion for the next month. She had obviously completed her agreement that we worked out through the case that ended in July by agreement. So then she's right back caught in this again, accruing late fees. I don't know if they'll add on another legal fee, either if they've already done it or if they're going to do it after again, and then she's going to get caught up in this endless cycle.
And what the main thing I was hearing, I mean, everything's important, but you said you could not find it in the lease anywhere that they're entitled to charge her for filing an eviction.
No, ma'am. And this is $205. So it's not an insubstantial sum. Plus, even if it were $1, if it's not in the lease,
right,
it can't be charged.
Was Ms. Avery apprised of this argument prior to this morning? Because I don't want to,
yes,
do shock and awe. Ms. Avery, do you have a response?
I believe she told me yesterday. Yes, it's a $205 and $70 fee, or 70-cent fee that was charged back in June of 2025. This is the actual cost to file an eviction. The landlord should not eat the cost of filing an eviction due to the tenant's failure to pay rent. I mean, they aren't. It literally costs that much to file an eviction. This is not an attorney fee. This is a filing fee that she was assessed, I believe, in June 12th, maybe, of 2025. So this was not something that just appeared in August. She was aware of it prior to August. It's not a fee that the housing authority has to eat. And if you look in their lease, I'm sure it said, and I don't have the lease right here in front of me to be able to quote it. And unfortunately, my internet's not letting me pick anything up at this moment. But I'm sure it's within that, the cost of having to file an eviction due to her failure to pay rent. I mean, she just wasn't a month behind. She was many months behind, and she still is on a repayment agreement. She has not paid this amount in full. She paid an agreeable portion to be able to remain. There's still an outstanding balance that she's making a $55, I believe, monthly payment towards to make sure that she's able to catch up on the owed arrearage. So at no point has she had a zero balance. She had an agreeable balance, but the $205 is based on her failure to consistently pay her rent, that they had to file the eviction that resulted in the agreement that they are into. So, I mean, they are not the ones that.
Sorry, didn't mean to cut you off. Go ahead.
Okay.
Well, you said at no point did she ever have a zero balance, which is a little different from what I've heard, because I thought I just heard from the defendant that she thought she had caught up at the end of the last eviction filing. So if we were to look at her ledger, in other words, if she came in and said, okay, I'm ready to catch it all up, would this 205 have been on there? Would she have had knowledge of that?
Yes, Your Honor, what she did was pay enough to remain and enter into a repayment agreement. Her balance is in the thousands, but they allowed her to pay, I believe she paid $2,000 or $3,000 somewhere. I don't know the exact amount that she paid, but that did not bring her to zero. They brought her to an agreement to repay the arrearage at $55 a month plus her regular rent.
Plus
I'm sorry.
No, I said plus the rent. I'm just getting this all in my head. This is going to need to be a hearing too, you all. We're at 10 o'clock. You all, everybody can say what the.
So,
wait a minute,
there's also clear waiver here. They've taken $800 from the HOPE program.
Okay.
Yeah, and I will just say that it's semantics to say that if she enters into repayment plan, of course she owes, but her balance is zero going from the repayment plan. Furthermore, if you took her money, if it was charged in June, then if you took her money after that, you've waived the right to terminate on that. And again, I have just reviewed this lease freshly. I don't see anything in there about that. And the idea that any contract, any party to a contract could add a term is directly in contradiction of how contracts work and how
I'm very aware of how contracts work, but I'm also how lease agreements work. And a person has an obligation to pay their rent, and they also have an obligation to be responsible for anything they cause to be incurred due to their failure to pay the rent. You're right. We could put this on for 3-9 if you want, but
I agree. I agree with both sides that the obligation has to be paid, but I also agree that the terms have to be in the lease. So I obviously need to review the lease, and we're going to have a great discussion because I have a feeling this may come up in the future. So the court needs to hear it and make a decision on the matter. Is everybody? We're now at hearing number 4, I think, on 319. 319 at 1. I know
it's 3-9. Is it 3-9 or 3-9?
I'm sorry, 3-9.
Okay.
All right, we'll see you all then for the hearing docket. Thank you. And that way we can spend more time and I can look at all the paperwork. Thank you all.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot spread myself something.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, let's we're going to start bringing people in here. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
I have no patience for that. I'm the one that needs it.